Good afternoon, everybody. I'm Catherine Barona with Levelset. Thanks for joining us for this webinar all about contractor licensing in Florida. And our speaker is Chris Cobb of Cobb Gonzalez, based in Jacksonville. And I will let Chris get started with his presentation. And if you have any questions, just put them in the chat box and we'll get to them either at the end of the presentation, or if it's pertaining to the material right at the time, then I will come back and ask Chris for you. All right, take it away, Chris. Thank you.
All right, thank you. Thank you for the opportunity to present on construction licensing. By way of background, I'm a construction litigation and licensing attorney in Florida. I have been a lawyer for 20 years, and I have, in 2012, was appointed by the governor at the time, Rick Scott, to the Construction Industry Licensing Board, where I served as the chairman in 2017. And so I have a lot of insight about the CILB, and given the parameters of today's presentation, I had to really think about what I was going to do to get us the most bang for the buck. And I kind of am distilling this very large body of law of licensing down into some practical applications that will help you assist you through the daily aspects of your license. And in order to do that, I think it's important for me to start from a foundational basis and provide some definitions. We're having some technical difficulties here with my screen share. There we go. So in order to get an understanding about the licensure and how it plays with Florida statutes, we have to understand its originations, and it is created by Chapter 49 of the Florida statutes. Chapter 49, while it gives the CILB its existence, the licensing board has the capability of creating its own laws and rules to govern its activities. And those laws and rules are found in 61G4, sections 12 through 23 of the Florida Administrative Code. And so under Chapter 489, in conjunction with those administrative code laws and rules, that creates the body of law that construction licensing arrives under. Part 1 of Chapter 49 is construction contracting. Part 2 is electrical contracting. And Part 3 is septic tank. And for the purposes of our conversations, we'll be dealing with construction contracting, although the electrical contracting section does have a lot of parallels to the construction contracting. The makeup of the board is important to understand because it is Florida's largest professional board, and it has 18 members. And the members are statutorily broken down into subcategories. So there are 4 general contractors, 3 building or residential. There's a roofing, sheet metal, air conditioning, mechanical, pool, plumbing, underground utility, 2 consumer members, and 2 building code officials. And consumer members are non-contractors who are appointed by the board. I served as the Division II consumer member when I was serving on the board. And so the consumer members effectively act as the voice of the consuming public. The CILB is divided into divisions, Division 1 and Division 2, and there's specialty licenses created by board rule and even statute. Division 1 class of licensure are the GCs, BCs, and RCs, and then Division 2 are all the trades, and we'll get into those in a little bit. But again, it's the foundational requirements of the licensure start in the statute, and it's they are creatures of statute. And so when you look at the specialty licenses, a specialty license is assigned to a particular division for disciplinary purposes and initial licensure purposes by scope of work. For example, the marine contractor's license is a subset of the GC license, so it would be under Division 1, whereas the pool specialty decking licenses are Division 2 because they associate with scope of work for pool contractors. And so that's how they divide the specialty licenses up at the board level. So Florida, there are two types of contractors. There's certified contractors, which are statewide. They are required only to exhibit state licenses in the local jurisdictions to pull permits. And state certified contractors can perform their scope of work, which is defined by law, in any location in the state. And so it is truly a statewide application versus the registered contractor, which is licensed by the local jurisdiction. They typically are issued a competency card. They register that competency card, that local license, with the DBPR in Tallahassee. And those licenses are only permitted to work on their scope of work in the geographical area for their jurisdiction. So if your license is a local license for Leon County, which is where Tallahassee is, then you are only allowed to work in Leon County unless that county has a reciprocity agreement with other counties. Then you can work in other counties, but you need to make sure that you're only practicing in the geographical limitations. If you go outside the geographical limitations, you can be hit for unlicensed activity. So you got to be careful where you're working. More definitions that are really important for today, because we will spend some time talking about qualifying agents and what you have to do to qualify an additional business with your license. When you have a company that is going to be performing construction activities and contracting, it must have a qualifier. In the state of Florida, licenses individuals. It does not license companies. And so the individual obtains the license, and then from there, they effectively park that license with the company and they become its primary qualifier. As the primary qualifier, you are responsible for directing, managing, and control and supervising both the business activities of the company and the construction activities. Now, those are two separate categories. So you're responsible for both, all of the business and all of the construction. As a secondary qualifier, you're only responsible for construction activities on jobs for which you pulled a permit and you have no financial responsibility. And so you may ask yourself, what does it mean to supervise, direct, manage, and control both the business activities and the construction activities? Well, there's a series of questions that can be addressed that will dissect those underlying parts, such as, do you have the ability to contract? Do you have the ability to hire and fire employees? Do you have the ability to look at the bank statements? Do you look at the tax returns? Do you execute vendor contracts? And can you terminate a project if it's going bad? I mean, all of these questions are indicative of whether or not you exercise the control of the business and the construction activities. And so it's not, there's no definition, there's no statutory guidance or rule guidance on what that means. And so you have to kind of distill that from its subparts, which is those questions that I just asked. After we get through the qualifiers, and if you don't, a lot of contractors that I know don't want to run businesses, they want to build things. And so you don't have to necessarily run the business. You can delegate that to what's called a financially responsible officer. The financially responsible officer is would be responsible for the business aspects of the organization. They fill out an application. They have to go through credit reports and background checks, just like most qualifiers do. But they are primarily relieving the construction qualifier from the business responsibilities that he has. FROs, which they're also known as, financially responsible officer, the FRO may be subject to disciplinary action if they mishandle or mismanage the company. But it's the construction license is what gives the CILB most of its disciplinary authority. And we will talk in further detail later in the presentation about disciplinary matters and what happens if you get entrenched in some disciplinary action by the state. And lastly, from a definitional perspective, before we go forward with any other discussion, we have to understand the definition of a contractor. So what is contracting? Contracting is someone who, for compensation, and it can be a bid scenario, it could be bartering scenario, it could be anything other that you gain for value is a legal definition for compensation. Does by himself or herself or by others, so there's your subcontracting requirement. Himself, herself is self-performing, others through subs. And then you have this list of verbs that you can perform for contracting: construct, repair, alter, remodel, demolish, subtract, improve. Real property, any building or structure, including related improvements for real estate, for resale to others, and for job scope, which is substantially similar in scope to subsections 3A through P. Now, subsections A through P, those are the definitions of the scopes of work in the construction licensing statute. And so you're basically for money through yourself or others repairing real property that is identified as the scope in the statute. That is contracting. Negotiating and bidding for or advertising for these services also constitutes contracting. And so it's not just enough that you actually sign a deal where you are improving the property. If you are driving in a truck, advertising for roofing repairs, and you are not a roofing contractor, you are engaged in contracting because you are advertising for those services. And so it is important to note that just submitting a bid and advertising for the services also falls within the definition of contracting. So when we have our licensor categories, there's a couple of criteria that you need to fulfill in order to get the license. And again, this is foundational for everybody. So Division 1, and Division 2, there are examination requirements that test you on your ability to run a project, your business and finance acumen, and trade knowledge. The business and finance component of that test is very important. There is a push now to enter into reciprocity agreements with other states where we would require other people to continue to take the business and finance portions of the Florida test, but they would waive in through their project experience and other licensure until we can get into that with that new law change of last year. Every contractor has to have experience and or education or a blend of the two, and you look at it as a sliding scale. So if you have 4 years of college, you would need 1 year of work experience, whereas if you had no college, you would need 4 years of work experience. And so it slides up and down depending on how much schooling and work experience you have. You got to be financially responsible, cannot have any liens or judgments or bad credit. The statute provides that 660 is a credit score. You can bond around a bad credit score, but you need to have good credit. I used to have to give a disclaimer when I was giving presentations on licensing to say that the presentation did not reflect how a CILB would vote on an application. And that really comes down to this good moral character section. Because I'm not on the board anymore, I can tell you kind of how the board votes on these types of things. And so good moral character is not just being a good person. It means that your criminal background is not indicative that you would be committing fraud or assaulting customers. And what they look for in that is, do you have past domestic violence? Do you have to register as a sex offender in any part of the state? A drug arrest or DUI will not necessarily be a bar to entry to getting a construction license, but if you show an aggressive past, you're going to have to explain yourself when you get your application reviewed by the board. And then insurance, you have to show proof of insurance. All right. So CILB, just a quick set on the divisions. Division 1 is a general contractor, unlimited in scope. There are certain limitations in 49113 that for general contractors, such as they can put shingles and cedar shakes on roofs on houses that they build from the ground up, but they can't repair roofs. And so there's certain limitations. Building contractor, again, by statute, and then the residential contractor is pretty self-explanatory. It's single family, 2-family, 3-family homes not exceeding 2 stories. And then real quick, here's all the Division II licenses that are currently pursuant to the statute. And you have to know when you're dealing with unlicensed activity and where you can work and the lines that you can cross. A good example would be the swimming pool contractors, because a residential pool and spa contractor, you would think, can only work on residential, but that's not accurate. So a residential pool and spa contractor can actually perform complete renovations of existing commercial pools. And so you need to make sure that you are acting within the scope of your license. The Class C air conditioning contractor is an old license. They're not issuing those anymore, but I think there's still a few around. They are mostly a service type license, but they're not issuing any Class D air conditioning licenses anymore. And then here's a bunch of specialty licenses that have been created. There's cell tower, industrial contractors, marine, there's an irrigation license. And so these are all pursuant to the board rule. And so these licenses were created where the industry would come to the CILB and ask them to create a license. Now these licenses are not, many of them are not mandatory, they're voluntary, but in some respects, if you're going to be doing this work like the marine specialty contractor, if you're going to be doing that work, you need to get that license. All right, so let's get into more practical nature of the construction license. So applying for the ability to qualify an additional business entity is something that happens quite often. And it's basically you want to take your license and park it with another company such that you are not only qualifying company A, but you're also qualifying company B. And sometimes the license can be used, for example, if I had a pool license and a residential license, I would be qualifying an additional business entity with that license. And so those are the easy situations to address. But what happens a lot of times is you'll have a contractor who's, let's say, a general contractor, and they have a buddy who wants to get into the construction industry, and they enter into some kind of arrangement where he's just going to qualify also the company of his buddy. And so basically the one general contracting license would be qualifying 2 separate and distinct entities. And this is where the rules really provide some clarity as to under what circumstances you can do that. In order for that general contractor to qualify the second entity, they must meet the above categories here. They have to either have 20% or more ownership, or they have to be a W-2 employee of the company. And the term employee has very significant legal meaning. Other evidence to ensure control over the construction, in my time on the board, I only saw one matter that actually fell under that scenario. I have generated a qualifier agreement that I think would probably meet the scrutiny of the CILB to qualify another company, but you're going to be asked a whole host of questions by the board. The easy way is to either make sure you have that 20% ownership or that you are a W-2 employee. That's the easy way. What if you had 10%? 10% you could qualify another company, but the 20% or more and the W-2 employee, those you're gonna need to go to the board and explain to them in person at a hearing as to how you can control the operations and business as a 10% owner. And that's what they're really looking at. They're looking at what is your level of control, because if you're going to be the primary qualifier, if you will remember that definition, you're responsible for all of the construction activities and all of the business activities of the company. Well, how can you as a 10% owner control all of the business activities of a company? And so those are the kinds of things that they will flush out. And you can solve that by having an FRO appointed, but you will have to explain yourself to the board. You, again, as the qualifier of an additional business, have final approval over all operations. And no payments from that new business can be 1099. That's renting your license, and it is illegal. And so if you're going to go help your buddy and you're going to qualify his company and he's just going to pay you under a 1099, you're renting your license. Do not do that. That is a big no-no. If in fact, if you say how the board will ask you at the hearing, how will you be paid by the new company? And if you say 1099, it's grounds for automatic denial. And so you need to know that going in. Meet the statutory requirements and you should be fine. If it's going to be your third company that you're going to qualify, you have a mandatory CILB appearance, regardless if you own 100% of all the companies. So that's something that you should be aware of as well. The definition of employee is very important. Like I said before, an employee is defined as a person who receives compensation from and is under the direct supervision and control of an employer who regularly deducts FICA, withholdings, and workers' comp. You do not deduct FICA, withholdings, and workers' comp from 1099. You don't. So you do not meet that category. That is a very, very important distinction and is one that the CILB members take very seriously. So make sure that if you're going to be a W-2 employee, it's going to be a W-2 employment scenario and not a 1099 vendor. Another aspect of qualifying another company is if you want to enter into a joint venture. So you have to actually create the business entity, and the business entity needs to have the joint venture agreement. You can obtain authorization from the CILB prior to bidding to submit the bid, because remember, if you bid for work and you're not qualified, you are unlicensed. And so you can actually get authorization under joint venture to submit a bid. The joint venture must be qualified by a license holder eventually, and all members of the joint venture must sign a document saying that the license holder has permissions to sign the contract. And once the joint venture wins the bid, it has 90 days to make its it has 90 days to be qualified, which means you need to file your application very quickly, because you probably will be at least 60 days before you get onto the board hearing calendar to get qualified. And so make sure you have that application ready to go if you're going to go the joint venture route. And also, finally, on qualifying an entity, sometimes the qualifier may decide that he or she no longer wants to qualify an entity, and they pull their license or change the status. That organization may not engage in any contracting activities. They may obtain a certificate to continue work that was already in place, and they have 60 days to find a new qualifier. No new contracts until that qualifier is in place. So they have a short window of time to continue work to try to find a qualifier and to finish projects that are already going on. The next important, I think, more practical aspect of licensure is what happens when you find yourselves in discipline, and a lot of that is tied with unlicensed activity. And so we need to have an understanding of unlicensed activity. And again, that goes through the scopes that I went through earlier, and you got to make sure that you're working within your scope. And so there's a statute that says, as a matter of public policy, contracts entered into by unlicensed contractors are enforceable in law and equity. And what that means is that if you're an individual and you need to have a license and you don't have a license, it's unlicensed activity. Same thing with a company. If the business is unlicensed, if it doesn't have a primary or secondary qualifier. Now, when you look at licensure, the business tax license that you have to get, or the occupational license that you have to get from the county, is not considered unlicensed activity. We are talking about a certified situation or a registered contractor scenario. So it's the state licensure for to actually perform the work. And you might want to know what date is this analysis? Because I've got all this work that I need to get going, and I've got contracts lining up, and people are calling me, and I need to get my license. Well, the effective date for licensure or unlicensure is determined on the date of the contract. If there is no contract, it's the date of first performing the work. And so those are the effective dates. If you don't have a license and you have a material supplier who has provided materials, your unlicensed status will not affect the lien rights of downstream suppliers and subcontractors, so long as they are properly licensed for the work they need to be doing as well. And the doctrine of imperi delicti does not apply. And so what that means is if a homeowner or a customer approaches you and they know that you are not licensed, but they go through the work anyway, and then they don't pay you, you cannot, as a defense to that, one, your contract's unenforceable because you don't have the license. But number two, you can't go after the homeowner and say, they knew I was unlicensed and they hired me anyway. When you balance those harms, the harm is the unlicensed activity is the greater harm than a homeowner taking advantage of that scenario. And so yeah, well, he knew I was unlicensed defense does not fly. And it has zero application in unlicensed activity cases. There are 8 possible legal ramifications for unlicensed activity. They are loss of your contract rights, no liens or bond rights. There is a statute buried in the tort section of the Florida statutes that actually will provide treble damages. So if you damage a homeowner for $10,000 on a roof and you're not a licensed roofing contractor, that's now $40,000 damage model. There's violations for the building code, administrative sanctions, criminal penalties. It is actually a crime. Unlicensed activity is a crime, and you can be arrested for it. The local jurisdictions run sting operations all the time to pick up and arrest unlicensed activity. And so you can be arrested for it. There is a claim for disgorgement of all the money because your contract is unenforceable in law and equity. And it's certainly unfair and deceptive trade practices to hold yourself out as somebody with a license when you don't have a license. And that's not only just for conducting contracting, but it's also for performing work that is outside of the scope of your current license. So you either have the license or you don't. If you do have a license and you're a roofing contractor doing pool work, you're working outside of your license, that is unlicensed activity as well. And then Morrison is the case that sets the time frame for when you need to determine whether you're licensed or unlicensed as the date of the original contract. So that is set in case law. And then finally, if you find yourself in the unenviable position of having a homeowner or customer file a complaint against you, there is a process that you will go through. You will receive a copy of the complaint. They will provide you with an opportunity to respond. The department is conducting its investigation. I think that you need to be very, very careful about what you say to the department when you're being investigated. It is a quasi-criminal, quasi-judicial system, and these prosecutors know what they are doing. And I have seen lawyers draft long and really well-written letters that were trying to explain their client's conduct that only resulted in adding 4 or 5 more charges because the lawyer said too much. And so you need to be very careful. What happens is there is an investigation. The investigators will report back to the department. If the department closes the investigation, it goes away. If the investigation remains and goes to the next step, it will be sent to a probable cause panel. 2 members of the licensing board will look at the investigative file and determine whether probable cause exists for a violation. More times than not, if you're at the probable cause panel, you won't, other than knowing that there was a complaint, you probably won't know that you're at the probable cause panel. It is private and confidential, so it is not public record. If a probable cause panel determines that you have committed a violation, they will file a formal administrative complaint, and you will receive what is called an election of rights. And you have 3 options. You have the option to admit everything. You have the option to request an informal hearing in front of the board, which means I admit all of the facts, but I want to present to the board as to why I should have my penalty mitigated. Or you can dispute and deny the charges. My recommendation unofficially to everybody here is that you initially dispute the charges and file the petition for formal administration with the Department of Administrative Hearings. You can always enter into settlement arrangements or whatnot, but I have seen contractors who stick it in a drawer and they get disciplined. I have seen contractors try to think that they are smooth and can talk their way out of this, and they end up getting hammered in front of the board. And so you should choose to deny and let your attorney handle the process from there, because at that point you're engaged in full litigation with the state on your license. So you'll go through the DOA hearing, and I've got the possible range of penalties from dismissal of the complaint all the way to revocation of your license. And with the administrative matters come some appellate rights. And so it's not the end all and be all. Once the board acts, you have appellate rights. And so very quickly, some grounds for discipline of the license. These are the most common that I saw. The top three are probably the most egregious: financial mismanagement, valid liens not satisfied in 75 days, and abandonment. Those top three will open you up to a recovery fund claim, in which case the state will actually pay the damages and then come after you for reimbursement. And if you don't reimburse the state, you lose your license. Forged affidavits and false affidavits, that's a no-no. Deposit no work, or deposit and don't pull permits for the appropriate statutory time, that can lead to discipline. Civil judgments, proceeding on a job without a permit, and actually one that's buried in the administrative code is discouraging the service of a notice to owner. So if you're a contractor and you have a downstream trade, and you tell them that they better not serve a notice to owner on your customer, that is actually grounds for CILB discipline. And failing to honor a written warranty is also one that's buried in the administrative code as well. So if you have a written warranty and you're not honoring it, or you're not investigating and handling it, then you can be disciplined for it. And this is some information about the homeowners recovery fund. If that abandonment, financial mismanagement, or liens results in disciplinary action against you, the homeowner or customer can file a petition to get a recovery from the homeowners recovery fund. And these are some considerations that deal with the recovery fund. You, as a contractor, are obligated to have warning language. If you're doing residential work, to have this warning language in your contracts. If you don't have this warning language in your contracts and you are doing residential work, you run the risk of getting disciplined. It's a minor violation, but it can be disciplined nonetheless. There are also, under Chapter 713, a specific lien warning that you need to provide owners. And that's a little bit outside the scope of this presentation, but it's, again, another set of warnings that need to be sent if you're doing residential work in the state of Florida. And to wrap up, there's been a few new laws and developments recently. So this is not so new, but it's about 5 years ago, the recovery fund added the Division II contractors back in. And so for all the Division II contractors listening, you need to have that warning language in your contracts as well. And so it used to only be Division I, and as of 2016, Division II has been added back in. So you are now subject to recovery fund claims. There was a lightening of the experience requirement, and instead of schooling, if you have received honorable discharge from active duty in the United States military in any branch, you can use that military experience to get a license as part of your education criteria. Instead of showing college, you can show active military experience. You still have to have 1 year as a foreman in the trade, but you can use your military experience to offset some of the educational requirements. And very recently, this past year, the Occupational Freedom and Opportunity Act was entered by the legislature in Florida, and it basically is starting to loosen the requirements to become licensed in the state of Florida, and it affects contractors, architects, engineers, building inspectors, and home inspectors. And so Chapter 455, which deals with your Practice Act, was amended to require the board and the DVPR to enter into reciprocal licensing agreements with other states, which means there may be an avenue for you to go out of state to get a license through one of these agreements. And so this is actually being drafted and discussed right now. I actually submitted the first version of a reciprocal agreement to the Construction Licensing Board last week, and it was approved, and it's with the state of Louisiana. And so there is a reciprocal licensing agreement that is being discussed right now between Florida and Louisiana, and it's by way of a endorsement, an examination endorsement. And so that's something that's happening right now. And so just keep your ears out for further developments on that. Chapter 49 was changed. The inconsequential work, otherwise known as the handyman exception, the amount of the work value was increased to $2,500. It used to be $1,000, and that inconsequential work value has increased to $2,500. Changes for the time to upgrade your license have been relaxed. If you have a 4-year degree in construction with a 3.0 or higher, you only need to take the business and finance part of the test. You don't need to take the project management and contract administration parts of tests. And so that's, again, a lightening of the standards because you are demonstrating the education through your 4-year degree and high GPA. And then application by endorsement. This section allows out-of-state contractors with a license and who can demonstrate the technical competence to get a Florida license. And so part of the reciprocity that we're trying to establish with other states is that if an out-of-state contractor has this ability to come in, well, we want Florida contractors the ability to go out. And so we enter into these agreements that allow that two-way path. And so again, those are currently being drafted and debated and discussed right now at the department level. And so that concludes my presentation, and I have some contact information here, and I understand we may have some questions, but thank you for your time, and I appreciate your attention.
Thanks so much, Chris. If anyone has a question right now, just put it in the chat box there for Chris, or afterwards you can email him there, of course. Thank you so much for your time today, Chris. I know that our viewers got a lot of good information and help out of this. And we will be emailing the recording of this to all the attendees and people who registered. So look out for that by Monday. And I think anyone out there, not seeing any questions yet, but that was a great presentation, definitely.
Well, if anybody has any questions, my email's right there. Send them on, and I'll be glad to address them.
Sounds good. Then that concludes our webinar, and thanks for everyone's time. We'll be signing off now.